morning. My name is Michael Heyman. I'm an Israeli and Australian lawyer. I made Aliyah from Australia 11 years ago. In Israel, I work with private clients. I assist them with all family matters. That involves assisting retirees and people of all ages with wills, enduring powers of attorney. I assist couples before they get married with prenups, couples after they get married, postnups. I also work extensively in divorce mediation as well as litigation. And I assist people with purchasing their Israeli homes and property transactions. In response to your question about why is it important to draft a prenup, I often pose a question to my clients and I ask them, what is the most significant financial transaction of their entire life? So people say buying a home, choosing your pension track, your pension agent, having children, and those are all true. I believe that the two most significant financial transactions are death and marriage. Under death, one gives away 100% of their assets. In marriage, one enters into a 50% partnership where all earnings and assets accrued during the marriage are shared with a partner. So when something has got such magnitude and such significance, I believe that people need to understand the gravity and the financial significance of getting married. And that's why I believe that a clearly drafted prenup really establishes the financial rules that govern your relationship. Under Israeli law, there's a default regime whereby all property accrued and earned during the marriage is considered shared, equal communal property, and with certain exceptions, inheritances, gifts, and also certain pensions and allowances. Except this is a default regime that can be opted out of or slightly altered. Under a prenup, people have autonomy to determine the financial rules that govern their own relationship. There's a lot of creativity. It's a contractual agreement between husband and wife. And the truth is, it's not just husband and wife. It's also between common law spouses. In some countries, they call that de facto relationships, which by law actually have the exact same status as husband and wife in terms of division of property. So I believe that people should have the autonomy, people should have the foresight, people should also have the maturity to understand the significance of the relationship that they're entering into, and they should understand with clarity what they're getting into. And they should have a conversation about it. They shouldn't just have this attitude of, oh, don't worry about it, it'll be right, trust me. Because without a contract, there is a contract. There are rules that apply. And sometimes the rules that apply are not so fair, or they expose people to certain dangers. I'll give you certain examples of scenarios where I think that it's highly, highly important for people to have prenups. So very often, or on some occasions, people live in a home that's only owned by one of the spouses, husband and wife, and there's no debt, was bought before the relationship started. Just by the fact that they're living there together, by law, there can be it's called a kavanat shituf, an assumption or intention of it being shared. Sometimes that's not always the intention. So under prenup, one can clarify, this apartment is mine, this apartment is yours. We're living here together as husband and wife, but it's not giving either one of us a property or interest. Alternatively, you can do the exact opposite. You could say it is giving the other one a property interest. But what I encourage my clients to do is to have clarity on these topics. Map out and establish the rules that govern your relationship. Give some other examples. Often, or on some occasions, parents purchase property in Israel, they open bank accounts in Israel, and for tax reasons or just logistically, they have a child who already lives in Israel, who's made Aliyah. So they register the property in that child's name. They trust each other. They have a good relationship. The bank account, what a headache. Why should I deal with it from the US? I'll name my child, my son, my daughter, as a joint signatory, or even as a joint owner on the account. Unfortunately, when conflict arises, all of a sudden, this is not the parent's home. This is not the parent's bank account. All of a sudden, this house is a joint marital asset, and the other spouse claims that they want half. It's a joint bank account. The other spouse demands half. What I'm saying applies true in case of dissolution of the relationship, divorce, or separation, but it also applies in case of death. God forbid, if the parents overseas pass away, then is that property in Israel, which is registered to just one of the kids, considered to be part of the parent's estate, or was it a gift during lifetime to that child? Unfortunately, these topics litigate for years and years and years, and people fight over it. So I encourage people to have financial clarity over certain topics to avoid disputes within the family.